Florida allows you to carry inside your vehicle under Florida State Statute 790.25, subsection 4. This law was recently modified with a major overhaul to concealed carry. Let's discuss that now. The new law reads, notwithstanding 790.01, a person 18 years of age or older who's in lawful possession of a handgun or other weapon may possess such handgun or other weapon within the interior of a private conveyance if the handgun is securely encased or not readily accessible for immediate use. A person who possesses a handgun or other weapon as authorized under this paragraph may not carry the handgun or weapon on his or her person. Subsection B. This subsection does not prevent a person from carrying a legal firearm other than a handgun anywhere in the private conveyance when such firearm is being carried for a lawful use. Or this subsection does not prevent a person from carrying a concealed weapon or a concealed firearm on his or her person while in a private conveyance if he or she is authorized to carry a concealed weapon or firearm consistent with the provisions of 790.01. This subsection shall be liberally construed in favor of the lawful use, ownership, and possession of firearms and weapons, including lawful self-defense, as provided in 776.012. The requirements of the law haven't changed. They just try to make it easier to understand. In this next section of the interview, Mark and I discuss the notification requirements. If you're carrying under 790.25, you don't have to notify or provide law enforcement any form of ID related to carrying a weapon. Let's jump into the interview. If you're carrying under this statute securely encased in your center console,
correct,
there's no legal duty to provide the police officer with identification because of the nature of having the gun. You may have to provide ID for another reason, but if
correct,
you're carrying down the road concealed on your person and the police officer asks you for ID, you're required to give it because you're carrying under the legal authority of the new statute, not under this provision.
I'm not so sure that if you're actually carrying concealment, law enforcement would know you have a concealed permit or a concealed weapon. So there's a whole bunch of questions that we could get to in another.
Yeah, no, I know we can't answer them here, but that is definitely one of the questions on everybody who's going to be watching this. Their mind is the statute says that you're required to provide ID upon demand of law enforcement.
Yes.
I think it's implied there that the law enforcement has to have some type of cause in order to ask you for that ID, but that's not written in the statute is the problem.
Totally. It isn't written in the statute, but I also don't believe that the Constitution requires you to identify to law enforcement. When you get pulled over for a stop, as you were talking about, you have to give them your license, your registration, proof of insurance. You don't have to give them any other biographical information unless you choose to.
Right, but I think the constitutional provision there that makes us different is an inherently dangerous activity subject to regulation. So you talk about the truck driving industry, you don't have to have probable cause to pull over a commercial vehicle because they're a commercial vehicle and they subject themselves to additional regulations by doing so. Same thing with like strip clubs or places that sell alcohol. You can go in there and you can do a regulatory search based upon the fact that they're involved in this highly regulated industry. And I think the firearms or carrying a firearm may kind of push you in that direction. I don't know. What are your thoughts?
I would hope that it doesn't push us in that direction. At least I would advise my clients that they should not advise law enforcement if you get pulled over and they ask that question. I always try and keep the stops as short as possible because if you advise them that you have a gun in the car, even if you're carrying it correctly and lawfully, I think you're just asking to be removed from the car while they do a search of the car. If you're like me and your kids have access to the car and the friends are in the car, you don't know what's left behind. So
yeah, you and I are on a lone island there. I think the 4 or 5 total attorneys that I've interviewed on this have kind of defaulted towards advising in advance. And their logic, because I've asked about their logic seems to be, well, it's better to disclose in advance than to find, the officer find it and not, without you disclosing it. And that just doesn't make any sense to me because one, the police aren't going to be searching my car, so they're not going to find it. And if for whatever reason the police are searching my car, of course I'm going to disclose it before they get to it. So I mean, it's not like it's going to be some secret, but as far
But
as we're interacting on the side of the road, taking a license, there's no need. My gun's not going to jump out and attack anybody.
absolutely, and even if you take it one step further, even if you didn't disclose it to them before they open up your glove compartment or your center console, you still haven't committed a crime.
Yeah.
So I don't see the benefit of it.
I think back in my day as a police officer, a lot of people handed out their concealed carry permit almost as a, hey, I'm in the club too, let me out of a ticket. Since the release of the new law, many of you have commented about the 1995 school zone law. This federal law prohibits people from carrying a firearm within 1,000 feet of a school zone. That's a problem. The law exempts people who have a concealed carry permit, but does not exempt people who aren't licensed. Let's check out that section of the interview. Okay, Mark, so we had a big discussion a few minutes ago, or the past 30 minutes before we went on the air or live on this, about the federal gun laws and the 1,000 feet within the school. So that's another big question right now.
You mentioned school. The federal statute defines it as 1,000 feet from the school. So obviously that does not include just the school property, but includes 1,000 feet in any direction as crow flies from that school property, which would be private residences and roads and HOAs and other.
Yeah, this is a big problem. It's a lot of confusion. I'm not really 100% confident on my answer here. We're exploring law. We really haven't seen any case law on this yet. But the way it looks to me is the federal law makes it unlawful for a person to possess a firearm within 1,000 feet of a school unless you're on private property. There's an exemption there, or unless the state has given you a concealed carry permit and they've done a background check. So that protects concealed carry permit holders. But if you don't have a concealed carry permit and you're driving through a school zone on your way to work, and for whatever reason you get pulled over for going 25 and a 20, and now you're stopped in the school zone, and they say, hey, you got your gun on you? Yeah, I got my gun on me. You got a concealed carry permit? No. Well, you're violating federal law.
Yeah, that is my understanding. You're violating federal law just like someone who's smoking marijuana or cannabis is violating federal law. You could be arrested. You may be the one exception. So I would caution anybody who is going to be driving within 1,000 feet of school. And in Florida, that's probably, you pass at least one or two of those on your way to work or on your way back home from work.
The Florida law that authorizes you to carry concealed in your car has been around for a long time. And so is this no carry in school zones. So far, it's been no issue. Nothing has changed to suggest that these laws are now going to come into conflict. Like, I haven't seen one of these cases come across my desk at all from the state level. I haven't seen it. I haven't heard about or got any calls on it. I don't get a lot of federal calls, but I've never had anybody talk about this or know about this as a thing. Have you had an experience with anybody being popped with a gun in a no school zone?
No, none at all. And again, I think that would be more like an inroad for a federal agent who wants to get somebody. I don't think it would actually apply to the average Joe. I've never had the issue come up before where someone was arrested on a gun charge because they were in a school zone. Primarily, federal governments are not patrolling those school zones. It would be a local law enforcement who would make the initial stop. And there's no state crime that's committed or local crime that's been committed. They would actually then have to turn it over to the federal government.
Yeah, and I want to be clear here, Mark. I know you're riding this line of technicalities and you're trying to give as safe advice as possible. But I think the truth of the matter is the chances of those stars lining up, all of those things happening is very slim, to the point where, I'm not going to say it's an impossibility, but, you've never seen a case like it. I've never heard of a case like it in law enforcement. So I don't think you're going to see that unless, just like you said, hey, we're trying to go after this guy. We know he's got guns in the car. We want to get it federal. So let's stop him on the way. He's going through a school zone. Let's pop him here. Then we can bring these charges federal super easy. If you have a game plan like that, I think that's another scenario. But I don't think for blue collar Joe on his way to work, it's going to be a problem.
agree with you 100%. I think there have to be a target on your back by the federal government.
To wrap up the interview, I asked Mark some questions about stand your ground. If you're going to be carrying a concealed weapon or concealed firearm on or about your person or inside your vehicle, you need to be familiar with the basics of stand your ground. Let's check out this section of the interview. I'm going to segue into something here because I'm going to close out the video probably with stand your ground.
Okay.
Any experience with stand your ground or any understanding of that law that
Yeah, I've done a few stand your ground hearings.
I have one coming up next week, and I really like stand your ground hearings because it turns the tables where, in a motion to suppress, you've got to overcome the state's burden. And in a stand your ground hearing, the state has to overcome your burden. And it makes it enjoyable.
It actually puts the shoe on the other foot, as they say. You make the state attorney actually get on the defensive, as opposed to just throwing the accusations out there and having us defend it. The state has to bring in some evidence. They normally, in my experience, try and traverse those and try and get so that the judge doesn't have to make a ruling.
Well, I mean, a stand your ground isn't under C4. Can they still traverse it?
I've had people do motions to strike that it was not appropriate, but you can stand your ground to defend yourself or to defend, in my mind, any crime that's committed on you. It doesn't have to be a crime of violence. It could be a crime of trespass or
yeah. Well, you can protect property. Yeah, you can protect real property, private property, or
I don't even think it's limited to. I don't think it's limited to properties. I think any crime in particular, the way the stand your ground is written right now. I know what you're talking about. You're talking about self-defense,
right.
Which is you can defend yourself, defend another person, defend property. But that's different.
One of the things I've been trying to establish with stand your ground, I've been trying to get the judges to do an individual specific ruling that the officers didn't consider stand your ground during their investigation. And I think we're seeing a lot of that at low-level offenses. You talk about a homicide, you talk about a murder, or talk about a serious charge. I think they take their time with it. But I think you get the road patrol responding to a bar fight. They're putting people in cuffs without considering who started the fight, without considering stand your ground at all. And the law is very specific that prior to making an arrest, the police must establish that self-defense isn't an issue. And I just don't know what the remedy is, even if they didn't figure it out. So I don't know what I'm asking the judge to rule on or why, but I do want that ruling.
You talk about low-level offenses. We do a lot in the villages. So a typical fight between neighbors for you and for me, they're misdemeanors. But in the villages, they all end up becoming felonies.
And if somebody's bad on the elderly, that's right.
You touch somebody over the age of 65. So your stand your ground motions up there are always in circuit court, and there's no crime that's inconsequential to the person who's accused of it. So a misdemeanor crime, you could go to the county jail, but in circuit court, you go to prison for 5 years. I like to stand your ground for a couple of reasons. Sometimes it lets the victim know how difficult it's going to be, even if the case is not going to go forward. Sometimes it lets the defendant know you didn't really have a great case anyway. The judge is not going to grant it, but we can still go forward. Maybe a jury sees it differently. But sometimes the judges see it exactly the way we lay it out, and they find that the person did stand your ground and they're entitled to in Florida, which is interesting for me because I'm a little bit older than you, I think. And there was no stand your ground back in 95.
There's only 2 things left for you to do. Like the video and share the video. Part of your job as a responsible and armed citizen is to educate yourself in Florida gun law. Hit it hard.